When a police accountability case is filed, the conversation moves quickly. Policies are produced, training records are produced, lesson plans, PowerPoints, attendance rosters. The department says the police officer was trained. The plaintiff begins examining the records. The court begins evaluating whether the municipality can be held responsible. That progression is entirely understandable. But here's the question I can't seem to let go. What connects those records to institutional responsibility? Not legally, institutionally. Because somewhere between a stack of training records and a claim of municipal liability, there has to be a bridge. I've spent years inside police training, not simply delivering instruction, watching institutions make decisions about how officers would be prepared long before an incident ever occurred. That's a very different vantage point. It taught me something I had never considered early in my police career. Organizations are remarkably effective at documenting activity. What's much harder is explaining institutional function. They're not the same thing. A lesson plan documents the instruction. A sign-in sheet documents attendance. A policy documents expectation. But none of the documents, standing alone, necessarily explain how an institution transforms constitutional expectations into operational policing. That's a different question, and I think it deserves more attention. Over the past several months, I've read court opinions. I've listened to experienced civil rights attorneys discuss Monell litigation. I've observed conversations about qualified immunity, discovery, experts, municipal liability, summary judgment, settlement strategy. Those conversations are sophisticated. They should be. But I continue to notice something. The discussion often becomes a debate over whether the records are sufficient. I rarely hear the conversation pause to ask something else. Sufficient to explain what? That's not a rhetorical question. Because if a police department relies upon training records to demonstrate institutional preparation, then it seems reasonable to ask what institutional function those records are intended to represent. Not what they contain, what they represent. Those are different ideas, and I think that is vital because municipal liability ultimately asks court to evaluate institutional responsibility. Institutional responsibility is larger than individual documentation. That doesn't mean the records lack value. They absolutely have value. It means they may be carrying a burden they were never designed to carry by themselves. That's where I believe the conversation becomes interesting. Not because I'm questioning the importance of training records. I'm questioning whether it's expected that those records are to explain something much larger than themselves. After 25 years in policing, in one of the largest police departments in this nation, I've become convinced that police training deserves to be understood as an institutional function before it's evaluated as documentary evidence. It's not a legal opinion. It isn't litigation strategy. It's an organizational observation, and I suspect it explains why so many police accountability cases become battles over documents that everyone agrees exist, while the institutional system those documents are presumed to represent remains largely undefined. Maybe that's why some cases feel incomplete. Not because the evidence is missing, because the institutional bridge has never been clearly articulated. That's the question I keep coming back to. Not whether training occurred, not whether records exist, but whether anyone has clearly explained the institutional connection between the two. Because until that bridge is understood, both sides may continue asking excellent legal questions while overlooking an equally important organizational one. I'm Tom Loglisci. Thank you for listening to Police Praxis Audio Briefings.